BNSS Framework Overview. A. Amitabh Bachchan or AB equals trial in absentia. It means the provision allows the trial of an accused to proceed even in their absence, ensuring that justice is not delayed due to non-appearance. B. Police remand of 15 to 90 days. Description: BNSS allows for an extended duration of police remand, ranging from 15 to 90 days. See concept of 0 equals 0 for, regardless of jurisdiction, with the option to later transfer it to the appropriate station. D. ER equals electronic summons and witness protection. Description: through digital summons, the court can expedite the summoning process, and virtual witness protection ensures secure testimony without requiring physical presence in court, safeguarding witnesses. Electronic records and trial equals. Description: this feature promotes digital storage and retrieval of court records, allowing for quicker trials and easier access to case files. It also involves the electronic handling of documents and evidence. F. Forensic investigation. Description: forensic investigation within BNSS emphasizes scientific and evidence-based approaches to crime solving, such as DNA analysis, fingerprinting, and digital forensics. G. Video recordings of entire proceedings. Description: this provision mandates the recording of court proceedings, ensuring transparency and an accurate record of court activity. It helps in preserving evidence and may assist in appeals or reviews.
And expanded them to mob vigilantism. Way forward: legislation, enact a national anti-lynching law. Social media regulation, curb fake news and hate speech. Victim support, uniform compensation and support for victims. Accountability, disciplinary action against officials failing to act. By addressing legal, administrative, and societal gaps, mob violence can be effectively curbed. The Bhartiya Nyaya Sanhita, 2023, Sections 101 and 103 addressing murder and its punishment, while Sections 100 and 105 cover culpable homicide. By clarifying these nuances, the judiciary ensures that criminal acts are adjudicated proportionally, reflecting the intent and circumstances of each case. The Supreme Court recently differentiated between murder and culpable homicide in the case of the Tatreya v. State of Maharashtra, where it converted a murder conviction under Section 302 IPC to culpable homicide not amounting to murder under Section 304 Part 2 IPC. The case involved a 2007 incident where the appellant, in an inebriated state, poured kerosene on his pregnant wife during an argument, leading to her death from 98% burn injuries. Initially convicted for murder, the Supreme Court observed that while the appellant had knowledge of the consequences of his actions, there was no intent to kill, reducing the conviction to culpable homicide. This distinction highlights the key differences between the two offenses. Murder, defined under Section 300 IPC, involves clear intent, premeditation, and malice aforethought, with punishments including death or life imprisonment under Section 302 IPC. Conversely, culpable homicide, defined under Section 299 IPC, occurs without specific intent but with the knowledge that the act is likely to cause death. Punishment under Section 304 IPC varies: life imprisonment or up to 10 years if done with intent, and up to 10 years if done with knowledge. Culpable homicide often arises from sudden provocation or in the heat of passion, unlike murder, which is deliberate and calculated. Commander K.M. Nanavati vs. State of Maharashtra, 1959, was a landmark case where Naval Commander Nanavati was tried for murdering his wife's lover, Prem Ahuja. Initially acquitted by a jury under Section 302 IPC, the verdict was overturned by the Bombay High Court, and the case was retried as a bench trial. Nanavati was eventually pardoned by Maharashtra Governor Vijayalakshmi Pandit, Prime Minister Nehru's sister.
To this wave of crime.
इतना टाइम हो गया है, अभी भी हमारे जख्म ताजा हैं।